This wife and mom was accused of trying to hire a hitman to kill her husband, but it wasn't some covert contract killer like you see in the movies that prosecutors say she solicited. They said it was a juvenile that she wanted to get her out of her marriage by taking out her husband, a juvenile inmate who she was teaching English to behind bars. Now, if that wasn't shocking enough, it goes to a whole new level, because on top of that, she also sent this boy explicit pictures of herself and had sexual contact with him, and the jury in her case just reached a shocking verdict. We got a lot to unpack on this one. We're on the case, presented by Law&Crime. I'm Chris Stewart. Look, there are a lot of ways for people to get out of a marriage. None of them are easy, but you have divorce, some sort of amicable separation, but we have seen in so many true crime stories, someone thinking that their way out could be hiring someone to kill their significant other. Prosecutors in tiny Adair County, Kentucky argued that was the approach that 27-year-old Elena Bardin took earlier this year. Now, Elena was a teacher in the public school system, and she was assigned to help young people who were spending time at a local juvenile detention facility, people who were facing charges. It's admirable work. And it also appears that she was a very admirable person outside of work. She was a loving wife, it appeared. She posted videos on TikTok of date night with her husband, and she was also a mom. And she made sure that people knew just how much she loved her daughter. You can see in this post that she says, "My girl." It was posted on March 27th of this year. It was that month of this year. An investigation began, though, into Elena Bardin that would shatter that admirable image that she had both at work and at home. Investigators said that they were doing a routine search of the detention center, just looking for contraband, things like that, of the young people who are spending time behind bars. And during that routine search, they found on one of the juveniles what they called explicit materials. Some of those explicit materials were of Elena Bardin. This boy that they found the explicit materials on was the boy that she was teaching behind bars as an English teacher. Further investigation found that, quote, Bardin had subjected the juvenile to illegal sexual contact and provided him with sexually explicit images of herself. But not only did Kentucky State Police accuse Bardin of having sexual contact with this boy and sending him explicit pictures of herself, they also said that Bardin, quote, solicited a male juvenile at the Adair Juvenile Detention Center to kill her husband. Now that is surprising when you just take a glance at her social media, Facebook, TikTok. It seems like she's in a great marriage, but we always know that social media is only part of the story. The last social media post that Bardin made was on March 28th of her and her daughter. Now March 28th is important because that was a day after police found those explicit images inside the facility. It is unclear whether she knew what the staff had found related to her at the time she posted this image. But 4 days later, she certainly found out, because on April 2nd, Kentucky State Police put her under arrest. Bardin was arrested. She was charged with solicitation of murder, sexual abuse in the first degree, and distribution of obscene matter to a minor. Her trial just happened this month. And you think about the timeline, I mean, pretty quick compared to some of the other pretty serious trials that we follow here at Law&Crime. All of this developing in March and April, and here she is with a 2-day trial in September 2025. And at that trial, prosecutors said that Bardin had told the boy that she was teaching that she wanted to kill her husband, or maybe the boy could get one of his friends in his hometown of Louisville, Kentucky to do it. This is according to paper The Lexington Herald-Leader. Now, the motive, they argued, was that Bardin wanted out of this marriage, but she didn't want to split her assets with her husband in a divorce, and she did not want to share custody of their 5-year-old daughter. The newspaper writes that the juvenile was in jail on a murder charge, and Bardin, we actually have reportedly some of the things she specifically said to him that was found in letters and a diary that investigators got during their investigation. One of the things that she wrote this boy in a letter reportedly said, quote, "I know you say you'll take care of him, but shouldn't someone else do it to take the suspicion away from you?" Bardin also wrote in a diary that the boy would, quote, make comments verbally and in writing about, quote, getting rid of my husband. I would ask him what he meant. He was always very adamant that if he never did anything criminal again, he would do it alone. The Times Leader writes that Bardin's defense attorney, though, looked at all of this and said any sort of solicitation of murder that was going on, all of that was a joke between a teacher and a student. Maybe it crossed a line ethically, but in terms of her trying to hire a hitman to kill her husband, the defense said absolutely not. The letters, they said, about killing Bardin's husband, that they were never actually taken seriously. The newspaper did say that the juvenile testified and told jurors that he thought Bardin was serious about killing her husband, but he never actually planned to do anything about it. I mean, it is important to note he's facing a murder charge. He's behind bars. It's unclear if and when he would ever actually get out of jail. Bardin's attorney also appears to have attacked the credibility of this juvenile witness on the stand. And he tried to make the argument to jurors that this boy was grooming his teacher as much as she was reportedly grooming him. Tough argument to make, but we do see in cases like this that defense attorneys have to take those kind of stands in hopes of appealing to jurors. Now, when it came to the sexual part of this relationship, prosecutors presented explicit pictures that Bardin sent this boy. In fact, they say she went to Walmart to develop them. They also have security camera footage showing her going into the boy's cell, even though that is not allowed per the detention facility's rules. Detectives also read nearly 140 pages of letters that Bardin sent this boy, many reportedly including explicit language and sexual fantasies of this teacher, but also explained real-life sexual contact with the boy, and the boy reportedly confirmed all of that happened on the stand. Now, this trial lasted 2 days, and the jury came back with a shocking verdict. Bardin, this mom, this wife, this English teacher, she was found guilty on one count of first-degree sexual abuse and a count of unlawful transaction with a minor and distribution of obscene material to a minor. But this is where things get shocking, because when you think about the explicit pictures, if they have that, it is incredibly clear what she actually did with this juvenile. But when it came to the count of trying to get a boy in a juvenile facility to kill her husband, jurors found her not guilty. Perhaps buying that argument that part of her communication with this boy was a joke. Maybe the boy saying he never really thought about actually doing it or would have been able to kill her husband. Maybe that had an impact on jurors. Before we get back to this episode of On the Case, I want to talk about an important sponsor. You know, they keep us busy here at Law and Crime, so I need to fuel up to keep my energy up throughout the day. But a lot of supplements and bars that are meant for on-the-go snacking can just be a mess with misleading labels and really complicated ingredients. That is why I love what our sponsor Equip is doing. They have clean nutrition in mind, and they're all about real food first. Transparent sourcing, third-party testing, and no toxins or fillers sneaking in. Their Prime Bar, it's not just another protein bar. It is a grass-fed beef superfood bar. It tastes like dessert, so instead of those junky syrups and seed oils, Equip is built with real, functional ingredients like the 20 grams of pasture-raised protein and dates and honey for natural sweetness, so it tastes great. I keep a box on hand, so when I desperately need a sweet fix, I know right where to go, and you can as well. Go to equipfoods.com/onthecase. You guys are gonna love just how clean and delicious these bars are. They are going to be a household staple for you and your family, and Equip is giving my audience an incredible offer right now. You wanna hit the link here, go directly to equipfoods.com/onthecase, and you can use my promo code ONTHECASE to get 20% off your first order or 35% off your first subscription. We want to say a huge thank you to Equip for making the best bar on the market and partnering with me. Bardin, though she was found not guilty of that count, perhaps the most serious, she's still expected to do some pretty serious time in prison, or at least that's what prosecutors want. I'll tell you how much she could get in just a moment, but if she did actually want to get her marriage to end, the Times leader writes that her husband filed for divorce in May of this year, and he also filed for sole custody of their daughter. As for the prison sentence, prosecutors are asking for a sentence of up to 14 years in prison, so this former teacher, now former wife, soon to be inmate, is slated for sentencing in November. All right, joining us now to talk a little bit more about this is criminal defense attorney John Day. Thank you as always for taking the time to be with us here on Law and Crime. So they have the messages that she allegedly sent saying that she wanted this juvenile to kill her husband, but she's found not guilty. What do you make of that?
Thanks for having me, Chris. So this is an unusual one because the prosecution would not have brought this case unless they had a good faith belief that they had more than enough to convince a jury beyond a reasonable doubt that she was trying to hire someone, in this case, this minor, to kill her husband. So what we see is that the jury was very thoughtful. They deliberated on this and were able to toss out some of the charges based on the testimony they heard. She still was convicted of felonies, but the main case against her brought by these prosecutors failed.
And it seems like from what I've read that the defense's approach to the messages about allegedly wanting to get this minor who's behind bars in this juvenile detention facility to get him or one of his friends to go and take out her husband to get out of this marriage. And the defense seemed to be, she was never actually serious about that. How effective is that argument, the I was just kidding argument, in cases like this where you might have a piece of evidence like a note or something like that saying where someone actually wanted to do it?
Right. Well, I mean, in this case, it was effective, and the defense team was able to convince the jury that they shouldn't take it seriously. And of course, that's a blow to the prosecution. But again, remember, they were able to determine that in their eyes, she was guilty of, crimes of dishonesty, crimes that involve things like sending the material to the minor's involvement with the minor. So the jury was able to at least make some kind of distinction there. But the idea at the end of the day that the defense can say, look, don't take this seriously. She's just sort of, this is a humorous exchange between the defendant working at the facility and then these juvenile inmates, the juvenile people, the kids in detention. I mean, that must have been very effective in the eyes of the jury, because even though they were able to convict her, they still had doubt. They still had a belief that what the defense was saying was accurate. And remember, she did not testify, and they apparently didn't call any other witnesses. So this was solely based on picking apart the prosecution's case.
Because to your point here's someone who, there's evidence that she had crossed every sort of ethical line and legal line when it came to having sexual contact with a minor. She's sending these notes. There was like 140 pages. And I did note in the newspaper that I guess even the detective was blushing when he was reading these messages that she was sending the boy, because they were that explicit. It appears that they had some sort of motive, they believe, that she wanted out of her marriage, but not to split the assets, not have to share custody of their daughter. So it seemed like in a lot of cases that this is typically where it gets a guilty verdict. In cases like this, though, where you see kind of this split decision, what type of jury typically goes in? Like, what does that say about this group of people that they saw that? And how common is it to actually see a jury be able to kind of distinguish what she's charged from here and what she's actually guilty of here?
Yeah, it's an interesting point, Chris. And I'm thinking back to the maybe 1,000 jury trials that I've done in my career. And every single time, what I notice, and it's always the same, a jury is they take their job seriously. Okay, you may not like the outcome, whether you're a prosecutor or defense attorney, but the jurors are, this is their job. They're brought together, these are 12 people or 6 people or however many it is who don't know each other, and they're brought together and they're given this task, they're given this assignment to sit there and listen to this evidence. A lot of times it's incredibly disturbing. And so you've got situations where people who are strangers to each other sit in a little room, they're watching video, they're hearing disturbing testimony, they're looking over at a defendant sitting at the defense table. At the end of the day, they take their job seriously. And a lot of times I've disagreed with their verdicts, but I've never thought that the jurors in my cases didn't take their job seriously. In this case, in this Kentucky case, what we see is a jury that did take their job seriously. They sat down there and they were able to pick apart the case that the prosecution threw at them and said, okay, we believe parts of this, we don't believe other parts of this. And even though the facts here are incredibly disturbing, involving allegations of involvement with a minor at the juvenile detention facility, they were able to say to the prosecutors, basically, you didn't have it. You didn't prove it to us. And we took our job seriously. And we looked at the evidence and we were able to acquit her of some serious charges.
So the timeline for this from investigation to a verdict seemed very quick, because it was in March of this year, end of March, that they discovered these explicit materials. Then 4 days later, it's April 2025, she's arrested. And then here we are, it's a 2-day trial in September to determine whether or not she's guilty. That feels quick. What do you make of that timeline?
Yeah, it's quick. I mean, jurisdictions differ in terms of what their caseloads look like, but this does particularly seem like a quick track for the prosecution's case. And then, of course, the jury didn't take them too long to come back. I mean, they had some idea going into it what they wanted to do, obviously listening to the evidence. But it was probably my guess from having had these cases, types of cases before in situations with juries, they probably went into deliberations having some skepticism, at least, about the prosecution's case, because they were able to pick that apart and say, we're going to acquit her of these charges. So as the evidence is being presented, as the case is unfolding, they're being skeptical.
And this trial lasted just 2 days, which I think for some of the high-profile stories that we're often talking about, these are trials that go on for a long time. Brian Kohberger would have been 3 months. Sean Diddy Combs, that was determined to be a pretty long trial as well, far more than just 2 days. Very different situations, and I get that. But what goes into determining how long a trial is actually going to go, and in this case, just 2 days?
Yeah, well, both sides make an estimate for the judge. Prosecution looks at how many witnesses they have, what the type of testimony is. Is there a lot of, video? Is there a lot of photographs? And this, is there a lot of, in cases involving things like homicide, of course, you're going to have lots of autopsy reports and photographs. And this particular case was probably streamlined, it seems like, because it was, from the prosecution standpoint, it was relatively straightforward, not a lot of expert testimony, for example. That takes up a lot of time when both sides have battling expert witnesses who are testifying. The prosecution put together what they must have thought was a streamlined case, but given the verdict, you wonder, did they shortchange their office? Did they really have it together? Because when you go up and you lose on counts like this, when it's the most serious charges, you've got to go back and wonder, what did we do wrong?
What is on the prosecution side, and even for the defense in your work too, when it comes to determining, okay, here's the evidence we have and this is what we need to get? Because maybe in hindsight they're looking and saying, was there a witness that we could have brought? I know that they had the juvenile himself on the stand, and I'm sure they felt really good about him as a witness. The text message, or not the text messages, the letters, they had a diary from her as well, surveillance video of her going in, and that certainly made a strong case on the sexual counts that she was facing. But what is the strategy typically when it comes to making sure that you're telling a story that is one that can keep jurors engaged and not boring them, but also not shortchanging them of important facts?
Right. Well, you kind of hit on the key factor. If you're a trial lawyer doing criminal law, whether you're on the prosecution side or the defense side, you've got to be a storyteller. The best lawyers I've ever seen in court are also the best storytellers, and they're the ones who have been able to, whether it comes naturally or whether it's something you've worked on for years, you're able to put together a narrative in a way that a jury can follow it, can understand it, and can believe it. And at the end of the day, they can accept your version of events. So if you are, we see this a lot in younger lawyers, younger prosecutors, defense lawyers. They don't have maybe storytelling skills that they will develop down the road in their career. But that kind of stuff, jurors are used to things like watching lawyer shows on television and in the movies, and they see these streamlined presentations that are, polished and eloquent, and they go in there expecting that. They expect that. Sorry, I have a dog here, Chris. Apologize.
All good.
So the jurors go in there and they expect a streamlined presentation. They expect that the lawyers are going to be like the guys they see and the women they see on TV. The problem is it takes a while to get to that level, even if you're not on TV.
Yeah, because I'm sure even in cases, I even think back to Casey Anthony and like Jose Baez, like a showman, someone who was just very good at telling her story, and then you saw the verdict go in their direction. You think that that's the expectation even in a rural county that someone might have, like Adair County where all of this took place. I know prosecutors are asking for 14 years for her sentence on these 2 other counts that she was found guilty of. And even though solicitation for murder, not guilty, the idea that she had sexual contact with this boy and was, passing along explicit messages, very, very serious charges. What typically goes into a judge's decision in a case like this about whether or not she could get and I know every jurisdiction is a little different, but generally speaking, what a judge will look at to determine what that sentence will actually be?
Right. Well, remember, the judge has sat through the trial. The judge has been able to evaluate the defendant's honesty and character in that little window of a trial, even if it's a 2-day trial where they're watching them. Even though the defendant doesn't testify, the judge has the evidence that the prosecution presented, and the judge has been able to watch the demeanor of the defendant at the defense table. That's one thing that I think a lot of times is overlooked, is I mean, when you're in court at a trial, it's like you're putting on a play if you're the defense lawyer, and you have to tell your client, everybody's watching you throughout the entire thing. So even on a break, even when nothing's happening, eyes are on you. So, but the judge is going to consider criminal history. The judge is going to consider the nature of the offense, the person's own history. In this case, because she was in a position of authority, I think a judge is going to be much more severe in sentencing than if it was a different situation. Because when you're given that authority, for example, in her position teaching, a judge is going to say you abuse that, and so there's a penalty that's going to be stronger than what otherwise I would be giving.
Even though she was found not guilty on the solicitation for murder charge, I mean, there was evidence that she made comments that she wanted her husband dead, even though the defense said it was a joke. You had the juvenile on the stand saying that he at least thought she was serious. Reportedly, he said that, even though he felt like he was never going to go through with it and never actually gave it serious thought. Could that, even though she was found guilty, factor into a judge's decision about, well, she still said some pretty disturbing things, at least, about her husband to a witness that testified at this trial?
Yes, absolutely. The statements of the witnesses are going to be sitting in the judge's mind as the judge is making the sentencing determination. Judges are surprised sometimes by a jury's verdict, and in their minds they can sort of adjust the punishment to fit what they think really happened. Judges accept the jury's verdict, obviously, but at the same time they've sat through the evidence, they've heard the testimony. And, I've had cases where judges are frustrated that the prosecution couldn't close the deal and convince a jury. And so there might be some effort by a judge to say, look, I know how serious this is. And even though you weren't convicted of this, I know what I heard. And so you do see that from time to time. Obviously, a judge is going to want to apply what they saw during that trial. Even if it's 2 days, they heard plenty of evidence. So again, I think it's going to come back to the person's history, their position in the community, their position of authority. And is this an aberration, or is this something that this person has had a history of, behavior that's not appropriate? In this case, we don't know that. But at the same time, the fact that she was in a facility in a position of authority is going to obviously have an effect.
And I wasn't obviously in the courtroom for when the verdict was read, but I'm sure for that top charge, there was a moment of relief for the defendant that she wasn't guilty of that most serious charge. But then the wave comes for, you're still convicted of these 2 other charges, and you could spend some serious time, 14 years maybe. That's a good chunk of your life in prison. I mean, what are the emotions like on the defense's side? Where I'm sure as that lawyer, you're thrilled that it seems like some pretty good lawyering that went on during the trial, but at the same time, your client's still going away for a while. I mean, what's the emotion and the dynamic after that happens, the conversation with the defendant? Like, take us inside the room for that.
Right. Well, as a defense lawyer, you try your best to prepare your client for the worst case scenario. I mean, you say, look, the trial's over. You have some time with them after the jury goes to deliberate. You're waiting on the verdict, and you go through all the scenarios with your client. I mean, you've done this beforehand, but it really hits home when you're waiting on a verdict. You tell them, here's the possibility. Here's what looked good for us. Here's what didn't look good for us. Be prepared for the worst case scenario. And the best lawyers are able to prepare their clients for that eventuality. I mean, you look back at the O.J. Simpson trial, and you know that his lawyers told him, there's a real serious chance that you're going to be convicted here. And so when the verdict comes back and it's less than what the prosecution wanted, it's not, in this case, it wasn't a full acquittal, but the defense has got to be pleased with being able to get an acquittal on the most serious charge. And the client, the defendant, of course, is going to be relieved. They're still facing time, but it's not nearly as much as they would have been. So there's a sense of relief, even though it's very likely that they're going to do some prison time.
And then just lastly, you know that the prosecution and what they may present asking for 14 years, when she's sentenced in November, what can the defense do to try and limit the damage and the amount of time that she'll spend in prison?
The defense from now until the sentencing date is going to be focused on mitigating her sentence, providing information to the judge about who she is, what's her background, what led her to this place, what is there that that the judge ought to consider in showing some leniency. I mean, you put together a whole book on your client. You get family history, you get social history, medical history, work history. You talk to friends, you talk to neighbors. I mean, to do a really good job on a sentencing like this, you've got to have an entire, essentially a book about your client, about the defendant, to give to the judge to say, look, this is who she is, this is how she got here. She made a mistake. She hasn't made any mistakes like this previously, if that's the case. You basically are building a story about your client, about the defendant, that has to be based on facts, obviously, but you want the judge to look at it and say, here are a lot of reasons not to max her out. Here are a lot of reasons not to give her the maximum sentence.
And we'll see how it all plays out. I know she's going to be sentenced in November. Shocking verdict to see that not guilty come across, but of course she'll likely spend a good amount of time in prison. John Day, criminal defense attorney, thanks for breaking this down for us. It's always great to have you on Law and Crime.
Good to see you. Thank you, Chris.
That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.